Namaste, Tarek sir.
Hi, Shubham. How are you?
I'm good, sir. How are you doing, sir?
Good.
Hello, Vision, sir. Namaste.
Namaskar. How are you, Mr. Shubham?
I'm good, sir. How are you doing, sir?
Yeah, fine. Good morning, Tarek.
Hi, sir. How are you?
Fine, Tarek. How about you?
Good. Pleasure to meet you.
Yeah.
Okay, sir. So we are live on YouTube. So shall I begin?
Yeah. I'm ready. I mean, whenever I have to speak, I'm ready.
Okay, sir. So very good evening, good morning to the guests, Mr. Tarek Khan, sir, Mr. Vijayan, sir, Mr. Shubham Harrison, sir, the participants, the students, and everyone else present here. I am Riddhi Jindal, Chief Operating Officer at Law Internships, the online law school, and host for today's inaugural ceremony. It gives me immense pleasure to welcome everyone at the panel for the inaugural ceremony of the National Mediation Competition 2022, organized by Law Internships, the online law school, in association with JMVD Legal Indore. Now I take this opportunity to introduce our guest speaker, Mr. Shubham Harrison, sir, Director, Law Internships, the online law school, Assistant Professor and Placement Officer at PIMR Indore. Sir has completed his graduation as well as post-graduation in Constitutional and Administrative Law from Christ University, Bangalore. He's very much keen at teaching students and has years of experience in teaching and served as an assistant professor in various law colleges. He realizes the importance of internship program and is having an experience as training and placement officer with a demonstrated history of working in the higher education industry. He's very passionate about law internships, the online law school to greater heights. So now I would like to invite Mr. Shubham Harrison, sir, to introduce Law Internships, the online law school. Over to you, sir.
Thank you so much, Riddhi. And a very warm good morning to one and all present here in the session today. And thank you so much for accepting our invitation, respected Mr. Vijayan sir and Mr. Tarek sir, and also Mr. Amit Dubey sir, who is a partner at JMVD Legal. He is joining after some time. So the law internship organization is basically the platform where we provide internship opportunity to the law students free of cost. And the aim of the organization is to provide all the skills which is not provided by the education institute like government law institute and other institute. So our main aim is to provide all the certificate courses, all the competitions which is not in generally provided by the law institute, because I have done my graduation from Christ University Bangalore and I have seen there the culture is very much different with comparison to other government law institute. So the vision of law internship, the online law school, is to provide not only provide the internship opportunity. Actually, what I wanted to try to say, in India, as per the BCI norms rule 25, it is very much compulsory for the law student to at least finish one internship in one academic year as per the BCI guidelines rule 25. But in law colleges, in various law colleges, I can say the students and the faculties are not aware about this particular guideline of BCI. And as per the data of 2014, if we talk about, then we do have around 1200 to 1500 law colleges in India. And we have BCI team, Bar Council of team of consisting of 19 members in India, who are doing the survey, who are doing the taking care of these 1200 to 1500 law institute, which personally I think which is not a good number or an equal number to conduct a survey for to make a hold on these 1200 to 1500 institute. I mean, it is hard to understand how can 19 people of BCI regulating 1200 to 1500 law institute across the India. So now, according to me, as per to fulfill the criteria of rule number 25 and rule number 26 of BCI, I think in India we require one separate regulating body who can regulate this internship process. Because I have seen in District Court of Indore, I have seen in Tees Hazari Court of Delhi, where interns, I mean, the courtrooms are very small, and where councils are standing, and उसके just बगल में interns खड़े हुए हैं, and बहुत ही एक congested सा माहौल हो जाता है courtroom में. We require a proper regulating body who can regulate this internship process and make sure all the 60,000 plus students who are pursuing their career in law do internship at least once in academic year, right? And currently what is happening, having those students, those institute who are well versed about the internship program and other program, what they are doing, their students are doing internship twice in a year, thrice in a year, 4 times in a year. But what about those law colleges who are not aware about this internship program, and their students who are not very much, well educated about the internship program provided by BCI? So we need to look all the students equally and provide such a platform or such a regulating body who can regulate all these 10,000, 60,000 plus law students pursuing their law career in one go. So this is one vision of law internships. And the other vision is there are a lot of institute, including private and government, who are not promoting competitions in their law school. For example, moot court competition, for example, debate competition. They just following the traditional way of education. When I'm saying the traditional way of education, they want to teach students IPC, constitutional law, and the basic subjects of law, but they are not even trying to update their syllabus with the new emerging fields of law like IBC, like energy laws and other laws, right? So here while introducing this law internship forum, we do provide certificate courses on this emerging field of law like IBC, and we do conduct this competition, national mediation, national moot court competition, so that one student can hone their legal debating skills, right? So this is the whole vision to open this forum called law internships for me. And definitely so far we have provided around 2,000 plus law students successful internship from our end. That is free of cost. So yes, we are doing great, and that's all. Thank you so much.
Thank you, sir. We will definitely work hard and live up to our expectations. First of all, I would like to warmly welcome Mr. Amit Dubey, sir. He has just joined.
Thank you very much. Good morning to all of you.
So with immense pleasure, I would like to introduce our chief guest, Mr. Tarek Khan, sir. Sir is currently working as the registrar of the International Arbitration and Mediation Center. He is a former partner of a leading arbitration law firm in India. He has been practicing as an advocate primarily in the Delhi High Court and Supreme Court of India. He has significant experience in domestic and international arbitrations, commercial disputes, writs, MSME disputes, insolvency and bankruptcy cases, and arbitration-related litigation. He has been listed in the Forbes Legal Power List 2020-2021 as one of the top individual lawyers below 10 years of practice, and was the youngest lawyer listed in Business World Legal 40 Under 40 2020. We welcome you, sir. Now, I would like to invite Mr. Tarek Khan, sir, to address the forum. Over to you, sir.
Thank you, Riddhi. Thank you very much. And a very warm welcome and good morning to my fellow panelists who are present here. It's indeed a pleasure to share my few words with all of you in this mediation competition, which has been organized by Law Internships. When I took up this opportunity of working as a registrar, I was asked one question, that it shouldn't be that you treat mediation like a stepchild, because you've been writing and extensively speaking about arbitration. And when I read about mediation, because I have been passionate about mediation also, but the only issue that I had was that mediation was not very successful and it was not conducted in a professional manner. At least this is what I have experienced in my years of practice. I have been a part of at least 30 to 40 mediations in commercial disputes. What I have seen is that mediation was only taken or probably chosen as a tool to delay the proceedings. Whenever a party wanted to delay the adjudication of a matter, they would always request the courts to refer the matter to mediation. And when the matter was sent to mediation, what I witnessed was sometimes the mediator who was appointed was not taking it very professionally, or was not very competent, or was not trained to conduct mediations, due to which most of the times I have seen that mediations fail. And the matter, of course, got delayed because there were multiple hearings, and for 6 months, 8 months, the mediator went on. And ultimately, it delayed the adjudication of the main disputes on merits. But now, at least the approach is changing, and I think ADR is taking over slowly. People have understood. They have realized the importance of ADR in general. When I speak about ADR, it's not just arbitration. Of course, arbitration is the most preferred method of dispute resolution. And I have been often quoted when I have said that arbitration is a preferred method of dispute resolution, and I have a major issue if people use the word ADR, at least for arbitration, because I think it is the preferred method of dispute resolution, at least in commercial disputes. And it is going to take over. It is the future. What Mr. Falias Nariman rightly said in the DIAC conference, I was a party to it. I was a witness. He said that the future of arbitration is bright because the future of litigation is not. The same, I think, goes for mediation in times to come, because the Mediation Bill has now been introduced. But there are certain problems with the bill. When I was analyzing it, I saw that they have introduced a Schedule 2, which I think is very problematic. They are trying to narrow down the scope of mediation and certain category of disputes which are not to be resolved by mediation, just like there was an issue of arbitrability, of fraud, etc. There is now going to be an issue of so many kinds of dispute they have exempted from mediation in Schedule 2. So I think the Schedule 2 has to go completely, and though they have invited comments, and I'm sure many experts have flagged this issue. But the way it is right now, I don't think it is going to flourish. So, but I'm glad that, such competitions are being hosted. And congratulations to law internships and to all the participants who are participating. And because, ultimately the awareness has to be generated. We must inform people about what mediation is, what are its benefits, but training is a must. Because what we have seen is, I was doing one discussion with RERA Bombay. They are resolving a lot of disputes by mediation and conciliation. Now, I told them that I asked them, in fact, what is your experience of doing these conciliation and mediation? The answer to that question was that in cases where parties have voluntarily requested for conciliation, those cases have more than 90% of cases where the matter got resolved. Whereas in cases where we imposed on the parties the urge to go for mediation, we told them you have to go for mediation. It's something which the authority wanted them to do. In those cases, mediation was not very successful. So I think the mindset of the parties has to change. We have a mindset of just, sometimes I met people and I'm really surprised how we have this approach. And, people say that I don't mind spending that much money on litigation, but I don't want to give it to that person. So, some egos are involved, what kind of battles people have. I think the mindset needs to change. And a lot depends on the mediator. Mediator plays a very, very important role in resolving a dispute. And these trainings, I think, need to stop, where you have a 2-day training and you get certified mediator in your hand and you say that I'm a trained mediator. I don't think a mediator can be trained in 2-day time. You need to have a proper certification. You need to have a proper training. And for that, I think we need to take certain steps. At least at IIMC, we'll be doing that. And we make sure when the disputes come to us, for instance, recently the Lalit Modi dispute was referred to us. So we are doing that. We are doing many others. We are doing like 5 to 6 big mediation matters in the country currently. And we make sure that the mediators who are appointed are extremely competent. So I think that's very, very important. A lot depends on the mediator. We cannot undermine the role of a mediator. And again, at the end of the day, everything comes down to what parties want and what is their mindset. So thank you very much. And I wish you all great success in this competition and many, many congratulations. Thank you.
Thank you so much, sir, for your insightful words. And the young generation is truly inspired with your work. So now I would like to take this opportunity to introduce our another chief guest, Mr. V. Vivijan, sir. Sir was educated at Dr. Ambedkar Government Law College, University of Madras. On completion of his legal education, he took up litigation practice at High Court of Madras in 1997. His enthusiasm towards ADR made him to pursue whole-time arbitration practice since 2001. He's an international arbitrator and mediator. He's also the managing partner at Cove Global LLP. We welcome you, sir. Now, with immense joy, I would like to invite Mr. V. Vivijan, sir, to address our young minds. Over to you, sir.
Thank you, Riddhi. Good morning to one and all, and I'm very happy to be along with the elite panel of Mr. Tarek Khan, Mr. Amit Dubey, as well as the director of the law internship. I'm indeed very happy to be present here amongst all of you virtually for this inaugural ceremony of the chapter 2 of this national mediation competition. To begin with, I'm very happy congratulating the organizers, law internships, for organizing such a competition, which has attracted the participation from several law schools, or as Mr. Kaur was mentioning about the law college, the traditional law colleges all over the country. It is always made to understand that the students were required to prepare the submissions like the memorials, the present arguments, and a contest about the jurisdictions. And all these type of moot court competitions happen to be very common. And it is very interesting to know that a law internship, along with their multiple tasks of complying with the Bar Council norms mentioned in Rule 25 and 26, this type of competition, which is very specific on the category of mediation, particularly developing the mediations techniques among the law students, is really a welcome note. And as rightly pointed out by the director of law internship as well as Dr. Tarek Khan, recently there is a great development when it comes to ADR. And specifically when the ADR was mentioned, arbitration was considered. Now the trend is also adding on with the mediation, which is rightly a good terminology which is used alternative to the conciliation. Such type of mediation competition has emerged as an indispensable part of the legal education nowadays. And this activity surely gives the students an opportunity to sharpen their skills, not only on the research part, and additionally, they are part of augmentation by exposing themselves to a simulated environment, particularly on ADR. Having attended, I personally attended that too after this pandemic, a lot of the virtual competitions. Beforehand, it was a physical competitions. In these competition, I can safely say that in some instances, the standard of questioning by the judges ultimately make the participants to sometimes even go to the level of not taking this option. But be assured, students, such type of competition is going to mold you. It is going to just develop your skill and bring out the possible exposures, what you are expected, like what law internship is trying to provide. I think according to the statistic, more than 2,000 internship has been facilitated by law internship. It is always good. Such participation of such competitions is going to strengthen your involvement, your approach, your perspective on a particular area of law. And one thing you have to be very clear, so this mediation is not only confined with law as well as a law curriculum. Now, this mediation or the arbitration is a domain of multiple professionals. It is also going to get involved the engineers, the engineering students, the medical students, as well as students from various streams can also get involved in this particular competition. And to begin with, I think it is very happy that all the law students are taking part in such competition. It is, however, necessary that the teams which are participating have to adopt the confrontational approach. This type of competition, particularly the mediation competition, which far better put up a strategy for the resolvers, that is the so-called the mediators, to analyze this type of dispute resolution and go towards negotiated settlement. A compromise or a negotiated settlement, it's always a welcome note. And I think the judiciary as well as the legal education also is going towards such type of negotiated settlement or a compromise, which is it is very much necessary. And as a law students, initially itself we had to get involved. In that sense, the pressures, the interest surrounding all these proceedings particularly have to be forecasted, and it has to be reflected in such competition. And the rival teams have to just initiate to go for the effective negotiated settlement, which is the need of the hour. While looking into such aspect of competitions, it does indeed motivate students like all of you to improve their skills. In long run, it is also kept to understand that there are shades of gray wherein they eventually take up practice, which might be in the commercial litigation or very sector specific litigation areas, or multiple opportunities are there. Here, when I'm commenting, I also need to just generalize my views about this particular legal education. What we can understand that several challenges it is obvious for all of us to overcome to pursue this particular aspect of constructive dispute resolution. The foremost problem is that of the resource constraint what we have in our education institution. And it is good that law internship through the virtual platform are doing wonders. But anyway, the traditional law colleges or the present day law schools spread over our country, more than 1,500 law schools, are finding it increasingly difficult to attract motivated teachers. We are not having the expected motivation, or the teachers who actually had to be mentors or who has to be the tutors are not available. And there are several underlying reasons for it. One, we can say that talented law graduates like all of you in future are increasingly driven to more lucrative career options. Nothing wrong in it, but you can just spare some reasonable time to develop this and particularly focus on such motivation when it comes to legal education. And the knowledge which is imparted through these rigorous ongoing engaged classrooms discussions often proves to be an important influence in your future career. But this process of learning and evaluation, which has to be conducted in a professional, innovative manner, I think participating in such moot courts, the mediation competitions, the counseling competitions, or debates, it is always a welcome note. And this would seed, and this is obviously planting a meaningful contribution in the future. Coming to the core competition, what we are here, that is the mediation. For many years, what you can see, the litigation seem to be the mainstream choice in resolving particularly the commercial disputes. And parties go to the courts to get the judgments, and they feel that the judgments are the only available outcome which can be effectively enforced. And it could also take some long time. The cost involved might be beyond what has been budgeted by the parties. And the court proceedings, which also has an options for the appellate opportunity for the parties. All these ultimately pay way as a great obstacle for the dispute resolution. And the mediation, which you are all here to participate for another couple of days, provides a neutral as well as really a confidential arena where the parties can communicate candidly and get the matter resolved. And this flexibility in mediation procedures, which is like a tailor-made remedy, allow the parties to have a greater autonomy, which is very much required. Litigants should have that autonomy on that outcome. And in that way, the mediation advocacy is developing. And to have a successful mediation, the major participant role, that is a mediator, is no doubt is a key. But each of the participating parties also has some role, and the mediation representative, the party's representative, or the party as such, as well as the mediator, all the stakeholders are developing this particular phenomenon. And as future legal practitioners, and in my exposure into ADR for the past 2 decades, participating in mediation would have ultimately an understanding that mediation advocacy involves a greater shift that you have to keep in mind from the traditional adversarial mode to a collaborative approach. And this collaborative approach is focusing on the interest of both the parties. That is very much important. And a common say in mediation is that it creates a win-win situation. And as participants in this competition, I feel that all of you also have to be leading to that win-win situation. And to a final note, what I wanted to share, this mediation bill, as rightly pointed out by Tarek, that the Schedule 2 has to be removed, which has a restriction for the capacity to mediate certain disputes. This mediation bill, which is presently in the Parliamentary Standing Committee, would also have certain positive sign. Most interestingly, this mediation is likely to become a career option for students, particularly the law students, with this creation of this Mediation Council of India, which which might be a new regulator. And now we are going to have a new career option, mediator, like advocate, and the already in the annual of the completion, the regulator, the Arbitration Council of India, which is going to grade the arbitrators. This Mediation Council of India is going to grade mediators. And these 3 options, whether advocate or arbitrator or mediator, is going to be the future. And this is going to be a great opportunity for not only participants like you in such mediation competition, and all the law students. And it is hope that participants will emerge from this competition with an enhanced understanding of how mediation can be effectively applied to resolve disputes of various nature, as well as I'm quite confident that such skills in mediation settings will obviously be relevant and also valuable in your future career, as well as your relationship, what you're going to develop and what role you're going to take. On this note, I wish all participants all the best. I hope all of you will enjoy this valuable, and surely it is going to be a fun learning experience. And I especially thank Mr. Riddhi Jindal for inviting to attend such an competition, particularly the inaugural session. And anyway, in the future rounds also, there might be some participation, and hope the next chapter, that is chapter 3 of the law internship mediation competition, would likely to be upgraded, or it has to be upgraded in an international level. Thank you. Best wishes for law internship to do a constructive mediation competition.
Thank you so much, sir, for your wonderful words. Now, I would like to take this opportunity to...
If it is fine, I just wanted to say a few things.
Sure, sir.
Tarek sir and Vivijan sir. There is one guidelines of UGC and BCI to introduce one mediation subject in all the universities, and that guideline is given by Bar Council of India, including the subject of the proper syllabus of mediation. And in the rule of that notification, it is mentioned that this particular mediation subject can be, those who are having experience more than 10 years, only those faculties, 10 years plus experience in the field of, mediation or arbitration can teach this particular subject. And what is, before this notification, we have mediation as a subject, but including with the alternative dispute resolution wala subject. But in the year 2020, BCI released one guidelines and make this mediation as a separate subject. And in that, they have clearly mentioned this particular subject can teach by the faculties who are having experience more than 10 plus years in the field of ADR or mediation. So I think in India, we do not having that much experience. N number of faculties which are so experienced in mediation to fulfill the BCI, but this particular norm, right? And also, I just wanted to say one thing that, as Tarek sir already mentioned, that training is very, very important for the mediation. I mean, conducting and participating in mediation competition is different thing, but training is also a very important part when it comes to the mediation, because one can become a judge, one can become a lawyer, but it is very much difficult to become a mediator. Right, on paper there are a lot of mediators, but in reality we know that mediation ka kaisa chal raha hai. The training is very important part, and I really wanted to introduce one training center in our institute, that is Prestige Institute of Management and Research, Indore. If it is possible, we can join hands together with Mr. Tarek Khan sir and Mr. B. Inba to open one prestige mediation training center. And as Innovations had mentioned, that mediation is now not limited to the law students, but we can also introducing this mediation with the engineering student or BBA student or MBA student. So it would be really great if we can combinedly open for all the streams that one mediation training center at Indore Prestige. So it can be I mean, कह सकते हैं एक step होगा towards to learn how to do the mediation, I guess. So yeah, thank you so much.
Thank you, sir. Further, I take this opportunity to introduce our guest of honor, Mr. Amit Dubey, sir. Sir is the practicing advocate at Madhya Pradesh High Court and a partner at JMVD Legal Indore. His practice area includes commercial litigation, patents, trademarks, design, copyright, geographical indications, and other litigation areas. Now, I take this opportunity to invite Amit Dubey, sir, to address the gathering. Over to you, sir.
Good morning to all of you. Thank you very much. And I'm seeing that law internships are doing very good work, and such mediation being a very old concept, but it is still very nascent. And if we see in the practical sense, we are not, it's being not used in its true sense. As an advocate, I'm practicing with generally before the commercial code. So we see a 12A as a very villain type of article, because whenever as a plaintiff we approach, so we have to satisfy the court that we have the urgency and the matter, and we don't want to go for the mediation. So generally as a plaintiff, we don't welcome section 12A, but generally we see that when a defendant has been approaching the court, he generally takes a plea that there are the chances of mediation in the matter, and 12A and even section 89 is being invoked just to delay the proceedings. So if we see before the court, mediation is not being seen as a very in a true sense, like it's a alternate method, and it has to be explored in its true sense. Mainly it is being seen as a forced mediation method. Generally in trademark cases, we have some urgencies are there, and always order 39 is being invoked under CPC, requiring urgency. Even commissions has to be appointed for search and seizure operations, and on such ground always plaintiffs tries to evade the mediation proceedings and 12A, but court generally just and still we have various parallel judgments, like we share you that our Madhya Pradesh High Court has taken a view that if you are filing an interim application under order 39 rule 1 and 2, so it has to be deemed that there are some urgency and 12A shouldn't be invoked. Apart from that, even some Madras High Court judgments we have where it is been seen, no, there's on case to case basis, urgency has to be seen and 12A can be invoked, and parties should be asked to refer to the mediation. So 12A is generally taken as is under the discretionary play of the court, and court is referring to the mediation in such matters. Now coming to the section 89, generally I've seen that the defendants, when they generally drop such various mails to plaintiff and asking for some settlement into the cases, and just 89 is mainly used, section 89 CPC is mainly used for delaying tactics in actual, and generally for seeking some time in the matter. So this is also not being used in the true sense. And even generally what happens in many cases, when both the parties have settled their case, even they have arrived on some agreement, and even mediation has been occurred outside the court, then also they try to make a section 89 application and refer it to the court mediation just to save the court fees. Because when we go through order 23 CPC, we don't get the refund of court fees. So it is very much surprising that a mediation is being invoked for such things, that only for refund of court fees or for delaying tactics and all. And even we have now a very welcome move has been done under MSME Act. We have a MSME facilitation councils in each state. So that are very good institutions, and they are taking conciliation work. Even matters are then later after conciliation, it is being referred for arbitration also in MSME councils. But the thing is that even if we, in true sense, we ask the advocates why you are approaching the MSME council, we get the answers, no, sir, we are having a very lesser court fees there. If we go to normal district court under a CPC, so we have to pay a huge court fees. So just I want to explain that neither the parties, and most importantly, nor the advocates are trained, and they don't know that what is the true spirit and effectiveness of a mediation process. And everyone is just like it's a forced mediation. That's why they are approaching. But I am of an optimist view that this forced mediation should become in a true sense, effective mediation, and everyone should go voluntarily for mediation. And I think the law internships, they are training the students and the future advocates, and such training sessions will make them a true voluntarily mediator in sense, and don't make them persons who will go for mediation in forced manner. In one of my case, I will just tell you that we were there at commercial court, and we got the party has just approached under order 7 rule 10 for return of plaint, but and they didn't succeeded, but they approached in appeal to High Court against our order 7 rule 10 return of plaint. That was only a jurisdiction issue. But when they approached the High Court, they raised a new point telling that the matter is under 12A, it can be referred to mediation. So 710 can't be decided and 12A should be seen. So only mediation point was raised just to succeed in appealing the matter. So I'm telling that mediation proceedings are not being used in a true sense, and the provisions are being used in another way as a prejudice to the parties. So I think such events will be very helpful, and it will make our provisions applicable in the true sense. Thank you very much.
Thank you so much for your advice, sir. Further, I would like to move with a vote of thanks. I, Riti Jindal, on behalf of Team Law Internships, would like to extend my heartfelt gratitude to our honorable guests for taking out time from the busy schedule and interacting with the participants. And I also wish all the participants and the organizing committee a very best of luck for the competition ahead. Thank you again, one and all.
Thank you so much.
Thank you so much, sir, for joining.
Thank you.
It was a pleasure to have you on board.
Hope to see you soon, physically, very soon.
Sure.